I would like to thank the organizers of today's event, which are KSU in collaboration with ELSA Malta and the SO. Firstly, I will be starting off by giving a brief overview of the panel discussion. Then I will introduce the speakers, and lastly, we will actually start off the panel discussion. So this particular campaign aims at raising awareness on various areas, including drug use and abuse by young adults, illicit drug activity such as drug trafficking, the effects of drugs on one's body and mind, enhancing law enforcement, and fundamentally, the national and European impact of drug use. In today's panel discussion, we will also be focusing particularly on the impact of the COVID-19 pandemic, of course, and the consequential effects on drug use disorders, prevention and therapy in the past few months. And in fact, this is one of the most crucial objectives of the campaign, which contributes towards the post-COVID-19 recovery aims. The panel discussion will be based on the current Maltese and European legislation, the member state competence in the sphere of public health legislation, the law enforcement system, the judicial system in the realm of drugs in Malta and within the EU, and a further discussion on enhancing such aspects with respect to drug issues in the EU, particularly in Malta. Special focus will also be given to discussing the criminal justice system and illicit drug activity in Malta, and basically how this system can actually be improved to reduce illicit drug activity. So as part of our speakers of today's panel discussion, we have 4 speakers. First of all, we have Dr. Joe Giglio, who is a senior and founding partner of the firm Lex Practice. Within the firm, he heads the criminal law department with a special interest in corporate and vicarious liability, as well as focusing on issues of transnational crime and the prevention of money laundering. His area of expertise is in criminal law, and he has been working in the field for the last 27 years and is definitely considered to be a leading criminal law lawyer on the island. And in fact, Dr. Giglio also lectures in criminal law and procedure within the Faculty of Law at the University of Malta. Thank you very much, Dr. Giglio, for joining us today.
For the invite.
Our second speaker is Dr. Mario Sammus from the European Parliament Office in Malta. Dr. Sammus is actually the head of the EP office in Malta, and he specializes, of course, in European law. Before taking up his role as head of the EP office in September of last year, Dr. Sammus was a member of the Legal Service of the European Parliament, where he acted as legal advisor to the Economic and Financial Affairs Committee, and regularly defended the European Parliament's position at the European Court of Justice. Being an EU official since 2004, Dr. Sammus worked at the European Court of Auditors and at the Council of the EU before joining the European Parliament. Thank you, Dr. Sammus, as well, for joining us.
Thank you for inviting me.
Our third speaker, we have Dr. Tony Borge, who is a former European Commissioner and a former Deputy Prime Minister and Cabinet Minister. He is currently also a member of the Management Board of the European Medicines Agency. In 2018, he was appointed a member of the Steering Committee on Constitutional Reform, chaired by the President of Malta. He was made Companion of the Order of Merit by the President of Malta in 2018, and he is also a resident senior lecturer in public law at the University of Malta. Thank you, Dr. Borge. And lastly, we have Judge Aaron Bugeja, who is a judge who sits in the Criminal Court and the Court of Criminal Appeal. He served as an advocate in private practice, and then subsequently he was appointed as a senior lawyer in the Office of the Attorney General, and was then eventually promoted to head its criminal law unit in August of 2012. Judge Bugeja was elevated to the bench, first as a magistrate in June 2013, and then as a judge in April of 2019. And Dr. Bugeja is also a visiting lecturer at the University of Malta, lecturing on the law of criminal procedure. So thank you to all the speakers for joining us today, and thank you once again to the organizers. If you have any questions, you can just post them in the comments, and we will be addressing them at the end of the panel discussion. So now I will be moving on to the first question, which is, how does the Maltese criminal justice system tackle drug use? And do you believe that this is effective enough to help reduce illicit drug activity and ultimately reduce drug use? So whoever wants to go ahead and start, you have the floor.
Yes, I'll set the ball rolling, Nina. I was minister responsible for police and law enforcement for about 10 years. And the law has improved in this respect. I remember that when I was appointed minister the second time in 1998, the law imposed a mandatory imprisonment to any drug trafficking, but drug trafficking was described as anything except simple possession. So even the importation of a drug for personal use was considered to be drug trafficking, equals minimum 6 months in prison. Sharing was drug trafficking as well. And the problem which I see is this mandatory imprisonment term. That is to say, when the judge or magistrate does not have any discretion whether to impose imprisonment or not. Now, technically, even for possession in the past, it was possible to send someone to prison under practice. No one used to be sent to prison just for simple possession. And the 2015 law, which was introduced, has formalized this matter. That is to say that even in cases of drug possession, you don't go directly before a court, but you go before the commissioners of justice. I stand to be corrected, but these are the same commissioners of justice which decide the party.
Yes, correct.
So from a fully fledged criminal proceeding, now we go for a commissioner for justice. And then it's only if you commit again a crime relating only to possession and possession for personal use that you go before the rehabilitation board. So there has been significant progress in this regard. I remember when I used to practice law many moons ago, that you could not be granted bail if you were charged with drug trafficking. I repeat, drug trafficking included even importation for personal use, even sharing. So the moment you give a drug, even 1 gram cannabis to someone else, that was drug trafficking. Mandatory 6 months imprisonment. And during the compilation of the evidence, you could not be granted bail, only following the human rights action after the Policino case related to drugs, that the Constitutional Court said you have always to leave a discretion to the court whether to grant bail or not. You cannot exclude bail a priori. Now, the problem which I think still exists is the following. I mean, do we need this mandatory imprisonment? Now, I remember times when there was no mandatory imprisonment. Mandatory imprisonment was introduced as a reaction to certain lenient judgments which were being delivered by the courts vis-a-vis real traffic, real drug traffic. Now, today, I stand to be corrected, but because I don't practice law anymore, there is a function of the rehabilitation board to develop a sentencing policy. Now, to what extent the sentencing policy in drug cases will be followed, to what extent is it binding? Of course, these things we can discuss later on. But if we were to develop an efficient sentencing policy, perhaps the time has come to remove the mandatory 6-month imprisonment, and this raises huge problems. I remember when I was a minister, you could have young people who are not minors being sent to prison mandatorily for 6 months. Then there developed a system whereby you spend 1 day in prison and then you go on a drug rehabilitation program. But why all this bureaucracy? I mean, why not trust the judges and the magistrates to decide when to impose an imprisonment rather than being forced to do so ex lege? But for this to happen, we must have an effective policy. This is my opening the debate so that we could see whether the current laws can be improved without, however, without allowing the sharks, okay, to get off the hook.
If around
Yes, it's okay. I mean, thank you, Joe, for giving me the floor. I do agree. I do agree with Dr. Borge in relation to the progression that we have seen. In fact, yes, a certain degree of progress was registered in the sense that at first the law was a little bit more repressive than the law that we have nowadays. It's basically the same pieces of law that we work with. So it's Chapter 101, it's Chapter 31 that are the main laws governing drug offenses. However, I think it's not simply the law that changed over time, it's also the outlook that society has towards this form of criminal offending that has also changed to a certain extent. And this change in the way society looks at drug offenses and the change of attitude towards certain types of drug-related offenses has also been reflected in certain laws that were introduced, not only in Malta, but also abroad. But let's focus on the Maltese situation. I do agree with Dr. Borch as well that Chapter 537 was a step in the right direction in relation to enhancing the concept of treatment of drug users rather than punishing drug users. I reckon that our law still makes a distinction between drug traffickers and drug pushers on the one hand, drug dealers on the one hand, and drug abusers on the other, in the sense that the law favors rehabilitation of all those who are drug dependent, who have a drug habit. Those who suffer from drug abuse need treatment. That is the philosophy behind this piece of legislation, essentially. When one goes into the nitty-gritty of it, one finds that, again, like anything in life, nothing is black or white. Everything has different shades of gray. Same with this law. So we find a shift in emphasis in favor of rehabilitation and treatment in this law. But as Dr. Borge said, in practice, this idea that those who abuse drugs should be helped was also found in the other laws, in the way they were implemented in practice, because courts were very sensitive to the plight of persons suffering from drug abuse as well. So as Dr. Borge said, it's true, nobody was sent to prison for simple possession of a cannabis joint for that. However, when it comes to tackling dealers in drugs, there the law becomes a little bit more draconian. And this is also reflected in practice, I have to say. When one looks at the development that took place with the Drug Dependence Treatment Not Imprisonment Act, I think that there again, we find more emphasis on the rehabilitation aspect rather than in the repression aspect. And this takes various forms, not only by the institution of the Commissioner of Justice role in relation to dealing with minor possession of drugs. I mean, if you have less than 2 grams of any drug and you possess less than 2 grams of any drug, not being cannabis, then you end up before the Commissioner of Justice. If you have less than 3.5 grams of cannabis, you end up before the Commissioner of Justice. Well, that is already, as Dr. Borge said, a huge change, if not development, from the old situation where the courts of magistrates were the ones to deal with these cases. Even, for example, certain niceties in this law. Well, if a person is found guilty, he or she can face a penalty ranging between €75 and €125. If we are dealing with cannabis, grass or resin, that is even lower. It's a penalty between €50 and €100. And what is a penalty? I mean, at law, we normally refer to financial to pecuniary punishment, either in the form of a multa or in the form of a menda. Here we find the concept of penalty being introduced, as if the law doesn't really want to consider these as criminal in nature. So you see, there are these niceties as well that were introduced in this law in order to try to distance criminal responsibility from the concept of drug use when it is minimal. There again, I mean, but it doesn't really stop there. This shift in approach is also found in the way this law deals with the concept of the drugs court. Now, when we are dealing with minor possession, the issue goes before the Commissioner of Justice. However, when drug offending increases in volume and goes through a qualitative as well as a quantitative shift, then the issue is transferred to a court of criminal jurisdiction. That can, in certain circumstances that perhaps we'll deal with later on, convert itself into a drugs court. Yes, there was a change in emphasis, there was a change in the approach, in the attitude, as we are seeing. But I think now it's time for me to give the floor to one of the other speakers, because I think it's not fair for me to steal the show here. But of course, I'll come to this later if need be.
There's no doubt, Nina, there is no doubt that throughout the years, our legislation and our judicial system have always bent backwards insofar as trying to provide assistance to drug users. I have been practicing in this field since around 1992, and I can tell you as a fact that in the numerous amount of cases that come to the courts where the charge is one of drug possession, the courts have always done their utmost to see that there is adequate rehabilitation. The difference that we have today is that before this act, which treatment instead of imprisonment act, all persons who were guilty of drug possession were brought to court, and they were given almost invariably a conditional discharge, meaning the court tells them, listen, I'm going to acquit you, make sure you don't do this offense again within a certain time period. Or if help was needed, they were given a probation order, and a probation officer was assigned to them to help them. What this new law has done is that in respect of those small amounts which Judge Bugeja has aptly pointed out, these people are not brought to court. They are instead taken to the tribunal, to the local council tribunal. And the offense of drug possession, only insofar as if the amounts concerned are what Judge Bugeja has pointed out, these minimum amounts, it basically means that you are given an administrative fine. Let's call it an administrative fine, and let's call it a penalty, because this is what the law refers to. It is equivalent to the penalty that each and every one of us is asked to pay if we park on a double yellow line, or if we basically park where we're not supposed to park. the advantage of this is that the administrative penalty, this penalty, is not recorded on the criminal conduct of the person so found guilty. So if I am going to seek a job and I go for my conduct sheet, if I have been condemned for drug possession, but my offense fell within the ambit of these local council courts, ġifiri less than 2 grams, or less, which Judge Bugeja aptly mentioned, then that punishment, penalty, 75 euro, 100 euro, won't appear on my criminal conduct certificate. Let us also keep in mind that prior to this act, whoever was found guilty of drug possession and given a conditional discharge or given a probation, or also at times given a fine, those convictions, if they were a conditional discharge on a probation order, they already did not appear on the conduct certificate of the person so found guilty. In the case of a fine, they would appear on his conduct certificate only for a period of 6 months after that this fine has been paid. But, so insofar as drug possession was concerned, we have always tried to assist and to help. As Judge Bugeja and as Dr. Borge aptly pointed out, however, we tended to adopt a very draconian approach insofar as drug trafficking is concerned. There could be various reasons why this has happened. I have my opinion about why this has happened, but it's not really important that I express my opinion now as to why this has happened. But from 1994 onwards, an enormous amount of legislation has been introduced. An enormous amount of amendments have been introduced, which were draconian in their approach and which, in truth, today, most of them have been declared to be anti-constitutional by the courts, by the constitutional courts in Malta. Let us not go into the details of which of provisions were declared anti-constitutional. Let us stick to the fact that our courts were taken away, it was taken away from our courts, the possibility, the discretion to give a prison sentence which was not a mandatory prison sentence in cases of drug trafficking. One of the biggest problems that were created were that magistrates and judges had a law which provided that if a person is found guilty of drug trafficking, if he is condemned by the magistrate's court, he is liable to a minimum mandatory punishment of 6 months. And if he is condemned by the criminal court, because we also had a law which said that the Attorney General could decide in which court it could be decided, which by the way has also been declared anti-constitutional since then, he was facing a mandatory prison term of 4 years. And various magistrates have had to unwillingly send to prison people who they did not want to imprison. And this is a fact. And they have only sent them to prison because, unfortunately, the legislation was that they had to be sent to prison. Let me give you examples of situations where our courts did not want to imprison people and they had to imprison people because of the very strict interpretation of what drug trafficking meant. I had a case, for example, I was, for example, going out with you, Nina. You decided to phone your drug trafficker to give you your daily 2 grams of cocaine. I do not even touch cocaine. I don't even abuse cocaine. You tell me, take me to my drug trafficker down wherever you decided to meet. And since I am driving, the drug trafficker decides, completely fortuitous decision, to come on the side of the driver, give me your cocaine sachet, which I take and pass on to you. I was facing, and I have known people who went to 6 months in prison simply because they passed on the drug sachet which Nina had ordered and which Nina wanted to consume. I had 2 Maltese ladies who once went to Amsterdam and bought pot, like some happens many times when you are in Amsterdam. They smoked these joints and they didn't like the taste of these joints and they decided to throw away the joints. But in Amsterdam, they serve cannabis in a way that is sort of like a lighter, and it's like a souvenir, and it's like it's you making sushi. There's an art in the way they present cannabis to you. And they decided to bring back these apparel that was given to them, and they brought it into Malta. When they were in Malta, they were stopped. And if whoever smokes knows that even if you have an empty packet of cigarettes, you are always going to find some traces of tobacco at the end of that packet. These two ladies came into Malta with the apparel that they got happy with their souvenir from Amsterdam, and they were charged with importation of cannabis, even though it was only very simple, basic, elementary traces of cannabis that they had. Both of them went to 6 months imprisonment because of the way the law was at the time. When we also try to introduce amendments, like for example, amendments insofar as drug sharing was concerned, why? Because there are various instances of drug trafficking. I could decide, I've had cases where a group of 5, 6, 7 people decided to go up to Gozo and decided to buy drugs so that they would consume them when they are in their flat in Gozo. When the trafficker came behind their door knocking to supply the drugs to them, the person who went to open the door and physically took possession of the drugs, which were not all his, but even also of his friend, was facing a 6-month mandatory prison term. We have also had situations, for example, which still exist and happen till today, where people are at parties, where people go into nightclubs and they decide that they want to buy ecstasy pills. We have had situations where 4 or 5 people decided together, 2 or 3 people decided together that they wanted to buy ecstasy. And one of them said, listen, I know who will sell us ecstasy in here, Mr. X, let me go and get the ecstasy pills. And because he went to get the ecstasy pills and bought 4 ecstasy pills, which one was his, one of was his friend, the other was a friend, and the other one was his girlfriend, he was also faced a mandatory minimum prison term of 6 months. So this issue of this mandatory prison term has created the greatest havoc in our judicial system. And this is why on the 1st of April 2015, the legislator passed a law, which is the law which we refer to Treatment Instead of Imprisonment Act. This law, although it has a very high-sounding title, has been changed and amended, and considerable relevant amendments, which we can discuss as we go along, but more than 4 times since when it has been introduced. The reason was because, in my opinion, it was rushed as a law, and it created many flaws and many difficulties. Let me give you one particular difficulty which I used to encounter with this law. One of the reasons whereby the court could convert itself into a drug court in order not to be obliged to send someone to prison for 6 months minimum, the law provided was that if I could show that he had grave and medical dependency on drugs. Now, explain to me how I'm going to prove to a court that a person who takes cannabis has a grave and medical condition. In the case of cocaine, I can do it quite easily. He's probably suffering from paranoia and has gone to a psychiatrist I don't know how many times. In the case of heroin, it's easy to do because he's probably taking methadone. He goes to detox and gets his methadone. But how do you explain that in the case of a cannabis user? The courts were very, very courageous, and they have taken upon themselves situations whereby experts have been appointed, and we have learned a lot of things. We have learned that cannabis dependency in truth stems from a lot of other conditions, ADHD, personality disorders, insomnia disorders. But this is how we have tried to overcome this flaw in the law, whereby people who cannot prove that the condition that they had was grave and medical could benefit from this new law. Fortunately, this part of the law has been removed, has been taken away. There are a lot of other issues where this law does not apply. Let me tell you another issue where this law does not apply. Another issue where this law does not apply, and therefore courts would still have to imprison someone for a mandatory prison of 6 months, is if the offense is committed within 100 meters of a club, school, youth club. Now, can you imagine in claustrophobic Malta, where that you would never have a situation that, for example, I am don't know, we're at university. Let's use university as an example. I am at university and I am down near the Msida roundabout, for example, sharing drugs with my friends. An architect is appointed. He takes a bird's eye view to see whether within 100 meters of the Msida roundabout there is a club, there is a school, there is an organization where youths meet, and if there is, and the prosecuting officer who has the sole discretion to so decide, decides to charge you with the fact that you are trafficking drugs within this 100 meter, then because of this 100 meter rule, this act, treatment instead of imprisonment, does not apply. And
Joe, jekk ninterrompik, darba kien hemm wieħed. Il-plaza, il-commercial center, jiġi 100 meters il-bot mid-Dorotej. Bissejda.
darba kelli
Għalek jiġi drug trafficking.
I had a case, for example, of a person who used to grow cannabis in his yard. It so happened that he lives close to the junior college.
College.
If you do 100 meter radius circumference. So there was a great risk, were it not for the fact that the prosecuting officer had the courage to withdraw the charge of the 100 meter. He was not obliged to do so. But were it not for that, this law would not apply either. There's also another flaw in this law, in my opinion, and another flaw is that this law only applies in those cases where the Attorney General directs that cases are charged, are to be dealt with by the magistrate court. They do not apply in respect of cases where the Attorney General directs that they are to be charged and prosecuted in front of the criminal courts. The Attorney General has his discretion. And there are guidelines as to when he can exercise this discretion. Amongst the guidelines as to when the Attorney General can decide whether a case is decided by a magistrate, meaning the punishment is 6 months to 10 years, or by the criminal court, meaning that the punishment is 4 years minimum to life imprisonment, is also the amount of drugs that are involved. But there are a plurality of drug traffickers who are mules. These people who are mules, and mules are people who carry drugs for other people, who are even in a situation where they swallow cocaine and sachets of cocaine to transport it from one place to another, and then excrete it, and once they excrete it, pass it on to whoever they have to pass it on. These people are drug traffickers, according to the definition of drug trafficking, yes. But are they the real drug traffickers that our legislation should be prohibiting from them the possibility to avail themselves of this treatment instead of imprisonment act? These drug mules get 200, 300 euros to swallow, I don't know how many capsules of cocaine, take a Ryanair flight and then go to the hotel that would have been pre-booked for them, excrete and pass on the drugs which they would have swallowed to whoever had them. They're paid 400, 500, 600 euros. These people are facing a minimum punishment of 4 years imprisonment, with a judge not having absolutely any discretion of not applying this mandatory prison term. So yes, there has been a lot of progression, but I still think that there's a lot that still can be done in order not to create situations in which people suffer. Nina, people suffer. It is difficult to understand the suffering that people are going through. There are drug traffickers who really are only trafficking, they're doing wrong anyway, don't get me wrong, but they traffic drugs to sustain their habit. It is a known fact today that a drug trafficker could find a runner, because they are called runners ultimately, give him 200, 300, 400 euros, or even give him what we refer to as a sapuna. Sapuna means 250 grams of cannabis. Sell me these 2 sapunets, this half a kilo of cannabis, and I will continue supplying your cannabis for free. This person is also not going to benefit from this new treatment instead of imprisonment, these high-flying words, which when you come to the brass tacks of it, you realize that there are so many flaws in this legislation that they still need to be addressed. I think we should start distinguishing between people who grow the heroin and the poppy leaves people who finance drug trafficking, who finance enormous operations of drug trafficking, and people who are runners, people who are mules, people who are in actual fact addicts themselves, who end up in a concept of drug, with a charge of drug trafficking, with all the consequences that these has brought with us. Insofar as the other instances that I explained, the parties, the going to Gozo, the happening to open the door and receive the drugs, the legislation addresses it to a certain extent and it addresses it appropriately. But there is still a lot, in my opinion, that needs to be done.
Thank you. So basically, I understand that the general feel is that although there have been efforts which have been made throughout the years, and there has definitely been a shift towards more rehabilitation and providing treatment, there's still a lot which is yet to be done, such as what Dr. Borge suggested, the more efficient sentencing policy, and through the examples as well that Dr. Giglio and Judge Bugeja gave us. So moving on to the next question, which is sort of linked to this as well. Portugal actually had decriminalized all drugs in 2001, which I believe is quite a radical measure. And it actually led to a significant drop in the overdoses, HIV infections, and even drug-related crime. Seeing sort of the positive outcomes of this radical change, which was actually done in another European country. So it's not something like America or somewhere, far. Do you believe that Malta should follow suit? Do you think it would work in Malta? And what do you think are sort of the risks which would be involved if we would do this? Maybe Dr. Sammus would like to start, but as in whoever wants to go ahead, feel free. If we could just keep our answers a bit more brief, it would be great. Thank you.
Thank you, Nina. Good evening. What is interesting here is that this shows us, when you mentioned the position, the situation in Portugal, this is already indicative of the fact that in the European Union, we have 27 different legal systems as far as drug regulation and drug criminalization is concerned. Every member state has the competence, has the power to regulate as they deem fit drug enforcement, drug regulation. And therefore, in the spectrum of 27 member states, we have systems which are more draconian than others, and there are others like the one you mentioned from Portugal, where there is a strong degree of decriminalization. In Portugal, it is largely a case of where you have personal use, it is an administrative misdemeanor, so to say, when you're caught using drugs for personal use. On the other hand, however, they do punish drug trafficking. Then you have a system like the Dutch system, for example, where they make a distinction between hard drugs and soft drugs. You have the Italian system, where focus is more on precluding trafficking. Again, so which one works better is something which myself as a lawyer, I don't think I'm in a position really to say. I think this is something which experts that deal with health are better placed to say, and perhaps practitioners also in this area can see the difference which a different approach makes. I think that the law should never be too draconian. I mean, sometimes we've seen cases before where people were very heavily penalized for what in today's culture are deemed to be more relatively minor offenses, personal use. Having said that, I think there is always the need here of psychological assessments, of proper studies to see which system really works better.
Sorry to interrupt. Do you think as well that maybe harmonization on a European level would be a good idea? So, for example, having, I don't know, one general directive or one general regulation, which would be then obviously transposed or directly applicable into the member states. I don't know if it has happened or not in this field, but do you think maybe that would be as well a solution, or?
That is a very interesting question, and here we actually we should make a bit of a distinction between legal drugs and illegal drugs. Now, this seminar is mostly it focuses upon illegal drugs, but we have legal drugs that are called medicines. And over there, we do have a rather strong degree of harmonization. We're seeing now that for vaccinations, for the vaccines, you have the European Medicines Authority that is authorizing the use of a vaccine throughout all Europe. Before that, pharmaceutical companies would have to go to individual member states and obtain permission from every jurisdiction. Having said that, the basis of that harmonization was not the article that deals with public health, but it was the article dealing with internal market, Article 114 of the treaty. So in that case, that article was coupled with the article on public health, and there was, and there still is, harmonization. This is something which for illegal drugs, we don't have. For illegal drugs, what the European Union does is coordination, it complements the member states' actions. And indeed, we have very little, I would say, legislation which has been adopted in this field. And where it's been adopted, it has been, the idea was to help coordination. I mean, for example, one regulation, it was actually there was a regulation in 2017 which amended the regulation regarding information exchange on an early warning system and risk assessment procedure for new psychoactive substances. That is one of the few pieces of legislation which we have in this field. Then again, the idea there is not to harmonize, but it is to inform, it's to coordinate. There is a Center for Drug Prevention, which is in Lisbon, and through this regulation, member states coordinate their actions, inform this center when there are new psychoactive substances, and therefore action can later be taken. But this is very limited. I mean, in this area, unless we have a change to the treaties and Article 168, which deals with public health, in a future treaty change becomes an area for harmonization, this for now cannot happen. There are movements to have public health move towards harmonization, but it is something that definitely needs to be discussed. Very often what happens is when there is this feeling that we need more harmonization, what happens is that they couple this article with Article 114. We've also seen it in the case of tobacco use. We have the directive in 2014 for tobacco products that was largely based on Article 114, even if tobacco is also mentioned in Article 168. And there is a specific provision dealing with tobacco over there. However, on Article 168, public health, you cannot do at this moment any harmonization.
To continue on this, Nina, if I may, because I was European Commissioner for Health, and there's a strong dose of subsidiarity on health issues. In fact, as Dr. Sammus said, when I launched the Tobacco Directive, there was no empowering section under health. I had to use the empowering section on the internal market, where one had to take public health into consideration. But I think that the COVID-19 will actually change something as regards the strong dose of subsidiarity, because we cannot fight COVID-19 in 27 separate states. But I don't think that this will lead to harmonization in drug laws, even because there are different opinions. After all, I was a minister for 16 years and an MP for 20 years. MPs reflect public opinion as well. Now, is public opinion ready for liberalization of drug laws to the extent that the mere possession of hard drugs will not lead to a criminal prosecution? I don't think so. I don't think that even cannabis, possession of cannabis, should be decriminalized, not only according to public opinion, but according to Caritas, for instance, who are experts on the ground. They are against the decriminalization of cannabis possession, even though one government minister had proposed to pass a law liberalizing cannabis to the extent that in the same way as you go to a bar and order a packet of cigarettes, you would order some cannabis as well, like the coffee shops in Amsterdam. But nothing came out of this, probably because of the reaction, of the public reaction to this. I think that we need to, first of all, eliminate the fragmentation of our drug laws. Why do we have two drug laws? The Dangerous Drugs Ordinance and the Medical and Kindred Provisions Ordinance. So ecstasy, for instance, falls under, not under the Dangerous Drugs Ordinance, but under the Medical and Kindred Provisions Ordinance. So it has happened in the past. I remember when I was an opposition MP between 1996 and 1998, I discovered that government had changed one law and inadvertently failed to change the other law. So if you were found guilty of drug trafficking in heroin or cannabis, you could go to life imprisonment. And if it was ecstasy, you could only go to 20 years. Changed. But why have two laws? I think we should have one law and avail ourselves of this opportunity also to modernize. Mandatory imprisonment. Everybody has spoken against mandatory imprisonment. Now, not to justify myself, but I found it there when I was a minister. So it had been introduced, I think, in 93 or in 94. But it also was a reaction to certain judgments which were being delivered by courts. That is to say that people who should have gone to prison were not being sent to prison. Now, I admit that as a consequence of the mandatory imprisonment, people who should not have been sent to prison were sent to prison against the will of the judge or the magistrate. But the solution in this respect, and perhaps now the time has come to revise the mandatory imprisonment rule, we can only do so if there is public trust in a sentencing policy. And the form of revision, after all, today the Attorney General, I stand to be corrected, I repeat, because I do not practice in the law courts. Today, the Attorney General has a general right of appeal from the magistrate's court's decision. So he can always appeal on the question of punishment, while before the Attorney General used to have a right to appeal only on points of law. Today, he can appeal on points of fact, on points of law, and even on punishment. So in the light also of this reform, which was introduced some years ago, again, because of certain judgments which were being delivered, perhaps the time has come to have a second look at the mandatory imprisonment. But this is not easy. I can just conclude by one anecdote. When I proposed to delete the rule that importation for personal use was automatically considered to be drug trafficking, it was extremely controversial. I was accused of sending the wrong message. The opposition had voted against, in a very long debate, they had voted against this proposal. So it becomes politically charged. The moment you liberalize a bit, it becomes politically charged. But I think that the time has come for this mandatory 6-month imprisonment thing to be reviewed. One last point. Now we have a law allowing the cultivation of cannabis for medical purposes. One has to be very careful here, because if we are going to issue license, and I don't know whether they have been issued already, or cannabis to be cultivated in Malta, are there any guarantees that the cannabis will not be used for purposes other than medicine? Because this could be a danger as well. Thank you.
And to follow up on this as well.
If you allow perhaps one point in relation to this part of the discussion. As for what Dr. Samut and Dr. Borge said, it is true, it's very difficult within a European context to achieve a harmonized stand because everyone has his own views on this topic. However, when you consider that Chapter 101 and Chapter 31 do not really take a particular hierarchical approach in relation to drugs. So basically, cannabis is a drug as much as cocaine or heroin is concerned. However, with Chapter 537, this Drug Dependence Treatment, Not Imprisonment Act, we find that as far as possession is concerned, the legislator has become a little bit more lenient in relation to possession of cannabis. And this is reflected in the difference in the manner in which cannabis is being treated when compared to other drugs. So for example, as far as the penalty is concerned, it is different. As far as the weight of the drug is concerned, it is different. When it comes to the Drug Offenders Rehabilitation Board obligation to refer, that too is also different. So for example, in the case of the second or subsequent conviction of a person in relation to possession of cannabis, the commissioner is obliged to refer the abuser to this board in the case of possession of cannabis only if the commissioner is convinced that the abuser is abusing also of other drugs apart from cannabis. So you see, sort of the legislator here is taking a relatively softer approach in relation to possession of cannabis when compared to other drugs. So yes, to a certain extent, this idea that our law doesn't really consider drugs, as I said, in a hierarchical perspective, Class A drugs, Class B drugs, etc. But here, thanks to this law, the drug dependence law, there seems to be a little bit of differentiation that is being not only considered but also implemented in our context. Then there is also a difference in relation to how to tackle situations where the ones that Dr. Giglio mentioned, where you can have a person who needs to finance his own drug habit by trafficking drugs himself. Most of the time, you will find these people doing it on a relatively frequent basis, especially if they are hugely dependent on drugs. But then again, this law, Chapter 537, does not exclude these people from the parameters of this law and from the possibility of the Court of Criminal Jurisdiction converting into a drugs court in relation to these people as well. Of course, it all depends on whether they would satisfy the criteria mentioned by this law. And that is where Dr. Giglio is right. Perhaps one should also revise the way the law sort of explains these criteria. In certain circumstances, one has to look not only at the minimum weight. So, for example, if you look at the schedules to Chapter 31 and Chapter 101 relating to the quantity or quantities of these drugs, you will find the magic number 300. So, for example, the quantity for cannabis, in order for it to be eligible or otherwise, it's 300 grams, right? If you go to Chapter 31, when it comes to ecstasy, we find 300, this time not grams, but tablets. This magic 300 number is also found in relation to amphetamine, 300 grams. What else? I mean, ketamine, half that, 150 grams. What's this 300-gram more tablet or I don't know. I mean, LSD, for example, again, 300 what? 300 squares. What's behind this 300 number? Is it a magical number? Is there a scientific basis for this? So yes, I think there's a lot of thinking that needs to go on here. And yes, this law needs refinement. It's a good basis, but it does need refinement.
Thank you. In relation to this as well, and this question actually ties in with quite a few comments which all the speakers actually have mentioned. This question is about the implications of the legislation of the medical cannabis which we had in Malta. And basically, just for the audience, here we are referring to the Production of Cannabis for Medicinal and Research Purposes Act, which was published in 2018. And this act basically brought about the possibility of the production of cannabis. However, such production was limited only to medicinal and research purposes within a regulated and controlled environment. So the question here is basically, what do you think were the implications of this legislation?
From my experience with this new legislation was that first and foremost, it has obviously it's being given out only in respect of persons who are given a medical prescription for it. My experience was a strange one, to be honest, with this medicinal cannabis, and it was as follows. I had persons who were accused of drug trafficking, and I opted to apply this new law, Treatment instead of Imprisonment Act. And after I had satisfied all the criteria for the court to convert itself into a drug court, the law then provides that the magistrate or the judge sitting in the Court of Criminal Appeal has to refer the person concerned to a drug board. And this drug board has to carry out periodic reviews of the person concerned to see how he's getting along. The law also establishes a maximum period of 18 months to review him. And then ultimately this board comes up with its opinion to the court. Now, medicinal cannabis has caused a problem for me in practice. Why? Because I have had various situations, more than one situation, where I satisfied the criteria laid down by the law, which, as Judge Borge has said, need to be readdressed because they slack. And I will give an example on the example that Judge Borge gave as to where they slack. For example, a person who was very heavily dependent on cannabis, because in his statement, he said that he has been trafficking cannabis for 2 years in order to finance and keep up his habit. The prosecution decided, and they asked him how much he used to traffic throughout the course of these years. And he, for example, told them, I used to sell a gram a week. So then they made a mathematical calculation saying, well, a gram a week times 52 times 2 years means you're over the 300, this famous 300, and therefore you are not entitled to be tried by the drug board. ANSI, they also considered whether they should be tried by the Attorney General, but by the criminal court. But let's not deviate. Well, and medicinal cannabis, I had this problem. The court did accept the plea that it should convert itself into a drug court, and it referred the person concerned to the drug board in order for the drug board to make recommendations. As soon as the drug board found out that the person concerned has been prescribed medicinal cannabis, they wrote back a recommendation to the magistrate telling her, listen, there's nothing that we can do for him because we cannot rehabilitate him because he has been prescribed medicinal cannabis. On the contrary, we suggest that you should revoke your decree converting herself into a drug court. So it has created a problem for me, practice, insofar as persons who have been prescribed medicinal cannabis and who also have a case pending where they are charged with drug trafficking, because the drug board is recommending to the drug court that people who have been prescribed medicinal cannabis, there is nothing that the drug board can do about them. There is no form of rehabilitation that it can do with them, and therefore it feels that it has no role to play. This can cause a problem because it means that the drug court is receiving from the drug board a negative recommendation. Fortunately, till now, although these particular, I have 4 or 5 instances where this is going on, these cases have not been decided yet. And I strongly believe that the magistrate will not go by the recommendation of the drug board and still apply, if it feels that the circumstances so exist, its discretion not to give a mandatory prison term. However, to the question, what was my experience in practice with medicinal cannabis, my reply to your question is as follows. I have had this problem, this impasse, which was created between the drug court and the drug board in respect of people who have been prescribed medicinal cannabis.
This is an interesting aspect. I mentioned a different aspect, that is to say, when the law on medicinal cannabis was launched, there were 2 main innovations. One, that before it used to be prescribed, but it had to be prescribed by a consultant, and now it can be prescribed by a general practitioner. But the second one, and here I think it's a bit dangerous, we are going to allow the cultivation on moldy soil of cannabis, even to export. Do we really need this, provided there is proper access to those who need medicinal cannabis through importation? Really, once we are going to allow land to be used for this purpose on moldy soil, what precautions are going to be taken that no one steals the cannabis for other use, that no one does? I mean, how is it going to be controlled that the cannabis is not going to be used for purposes other than medicine? Because I think it's very difficult to control it. So long as we are importing it for medicinal use, there is no obligation. But cultivating molda is, in my view, extremely dangerous. So I took up the subject from this aspect. Of course, the aspect mentioned is interesting as well on the other end. But do we need to cultivate it in Malta? Is it so rare? Is it so difficult to import it that we need to cultivate it? And if we have to cultivate it, are we going to introduce certain safeguards so that there will be no abuse in this respect?
That's correct. There's another safeguard which perhaps Judge Bugeja could answer a bit more, but as similarly to the lines that Dr. Borge is explaining, I have another question mark, which sometimes brings to my mind certain queries. When drugs are seized, they are exhibited in court, so to say. And then, after they are exhibited in court, they, at the end of the proceedings, they should be, strictly speaking, destroyed. Throughout the court proceedings, an expert is appointed to examine them to see that it is actually a drug, and part of the evidence the prosecution has to bring is obviously possession of the drug with which you are being charged. But are we adequately monitoring the destruction of drugs that are found and that are, in actual fact, presented as evidence in court? Secondly, who is monitoring those drugs which police find and which are not necessarily eventually exhibited in court? Why? Many times I have cases where people come to court and admit their charge. And what happens to those drugs which the police officer would have found? I'm asking this question even because I had a personal experience when I had a particular person, I don't need to mention this person, who always used to find 2 sachets of cocaine in the toilets of a particular club. All the time. Whenever he went to the toilets, this police officer, he always invariably found 2 sachets of cocaine. And it kept on breaking up my mind until I finally asked him to physically exhibit these cocaine sachets to make sure that finally they are destructed. But The point by by Dr. Borge is a very, 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 very valuable point. And I too wish that we have better safeguards. I know that the magistrate and the judge ordered their destruction. I know that they asked for a procès verbal to be drawn up to make sure that they are destructed. But what supervision is there to ensure that what actually has been found and what actually has been exhibited is indeed destructed?
Well, if I may add to this very, very pertinent point, invariably in these judgments, whenever drugs are seized, the Court of Magistrates and the Superior Criminal Courts do order the destruction under the supervision of the Registrar of Courts. Neither judge nor magistrate would be present when this process takes place. So really, it's a question of trust that one has to have in one's authorities. I mean, who is going to be the supervisor of those who should be supervising over law and order? I think that is a very, very pertinent issue. One other point that I wanted to sort of mention here while we're dealing with cannabis cultivation and stuff. I'm not going to go into the policy issue of it. I mean, I'm no politician. I'm a technical person. I mean, and I'm part of the judiciary, so I'm not really interested in the political aspect of it. But fact is that throughout the years, I mean, I could see from my own professional experience a change in approach towards cannabis use. And probably with this idea that cannabis can be used also for medicinal purposes, the idea mentioned that by the 2015 law, relaxing a little bit the law relating to possession of cannabis is conveying this idea that being in possession of cannabis is like something which isn't really that bad, you know? When at the end of it, I mean, severe and serious users of cannabis can suffer a lot of physical consequences along the years. Well, even smokers do, all I know, and even those who abuse alcohol eventually might end up with a fatty or damaged liver, as far as I'm concerned, you know. But I think that this idea that cannabis is like a soft drug, where if you get caught with less than 2.5 grams, nothing really bad is going to happen to you, apart from a petty penalty, you know. And if you're caught over and over again, I mean, again, nothing tragic is going to happen to you because you're not going to be referred to the board if you're not abusing other drugs. You know, I mean, this idea that kollox jgħaddi sort of with this might be giving a wrong impression. It's true. As Dr. Borge said, politicians try to reflect as much as possible their electorate and their thoughts. And probably, I mean, in this day and age, people look with a more relaxed attitude towards cannabis and cannabis use. I mean, I think that is fact. Whether that fact is good for these individuals who use and abuse cannabis and for society in general, well, that's a totally different kettle of fish, I think.
Thank you. I actually think that this is a very interesting point that you're saying that there has been sort of a change in approach, even sort of by lawyers and by the judiciary to the use of cannabis. And this would actually lead me to my next question. Do you think that Malta will ever fully legalize recreational cannabis? And do you think this would be beneficial? I mean, what would be the impact? I mean, a lot of papers have been published. Even, for example, there was one, I believe, by Elsa Malta, who's part of the organizers of this event. I mean, there's been a lot of sort of talk about legalizing cannabis as a recreational drug, but what would actually is this possible in Malta? Do you think what are the impacts of this?
I mean, drug abuse, it's a question of licensing, really. I mean, when you have a look at the law, it's a question of whether one has the required authorization to be in possession, to sell, to import, etc., etc. So it's a question of giving an authorization to a person to possess a quantity, blah, blah, blah. I mean, the issue, I think, is not really that. This shift in approach, these changes in the law, and this relaxed attitude towards cannabis is clearly pointing towards that direction that you are mentioning. From a legal perspective, I'm not mentioning the criminological aspect, the political aspect, etc. I'm not going into that. But from a legal perspective, definitely, you can see this shift towards leniency in relation to this particular drug when it comes to its possession. I think that is fact. Whether this progresses even further, well, that is not for me to say. But definitely, from a legal perspective, there seems to be this shift.
I agree with Judge Bugeya that there is this leniency, and I think it was the right thing to do. But I am against decriminalizing completely cannabis, or what is called recreational cannabis, for two reasons. First of all the medical experts say that it does cause harm. Now you might tell me, but even smoking causes harm. Well, probably if tobacco were to be introduced, had to be introduced for the first time, now we would prohibit it. In fact, in the world, there's just one state in the Far East, Bhutan, where it is the possession of tobacco is a criminal offense. It's considered to be an illegal drug. But it would be very difficult today to criminalize tobacco consumption. However, cannabis in Malta and in a number of other countries has always been considered to be something illegal. Now, the fact that it's illegal doesn't mean that you go to prison. There are other ways of punishing of sanctioning without going to prison. But the second reason, apart from the medical effects, is that, and this is a very strong argument, that if you allow the liberalization of cannabis, that you can go and buy it from a shop in the same way as you buy a packet of cigarettes, this could lead you to contact with harder drugs, and that drug traffickers will first entice you to the legalization of cannabis to consume cannabis, and then, of course, the second stage would be heroin and coke. These are the two main arguments against it. I have no doubt criminalization will solve problems, but it would create others.
And maybe if Dr. Gilly or Dr. Sammus could give us some more insight on whether you think this is actually the direction in which Malta is heading. I mean, do you think it is actually going to happen, that it will be legalized in terms of recreational use?
It's a little bit hard to tell. I think what is needed is definitely a study on whether that could lead to the use of harder drugs, as Dr. Tony Borge said. If I were to make a bit of an analogy, it's a different field, but if we were to look at tobacco regulation, there was found that when people started smoking, for example, menthol cigarettes or cigarettes with a pleasant flavoring, vanilla or strawberry, whatever, that eventually led to smoking normal cigarettes, which is why the 2014 directive on tobacco products actually banned the use of flavorings in tobacco products. Over the last years, we saw the elimination of vanilla, for example, and other flavors. And this year, it's the end also of menthol cigarettes. There was a derogation for a while, but now they're gone as well. in that case, there was actually a proved study that starting with these easy, so to say, easy flavors, which masked the harmful effects that made tobacco even taste maybe pleasant, would lead to the harder smoking. Now, does the use of marijuana for recreational purposes actually lead to use of cocaine, of heroin, of harder drugs? I think that is something that needs to be very seriously looked into. It's important that we look at scientific studies in this respect, at studies that are provided by experts in the field. And I think any move towards the criminalization should first be based upon this kind of study rather than simple public opinion without having an informed scientific basis.
One other thing perhaps to look into is really to tie up with what's being said by the other speakers. Yes, looking into what harm or benefit these drugs have on human physique is also very important. I mean, for example, nowadays there's a lot of talk about medicinal use of cannabis. Fine, I mean, that seems to be fact. We do have legislation in place. It's strictly controlled. It's very strictly administered. It needs the authorization of the superintendent of public health in order for it to be administered. It has to be administered through an authorized pharmacist from a pharmacy. There's a lot of legislation in place, so it's not that easy to avail yourself of this preparation. But then again, I mean, in the past, let's face it, even cocaine and cocaine derivatives were used to treat depression, for example. So should a person suffering from depression now be eligible also for cocaine or any derivative of it? You see, I mean, these things are not that easy. I mean, they are very complex issues, and of course, having a proper scientific understanding of the effects of these substances, of the active ingredients on the human body and on the human brain and on the human being as a whole is very important when it comes to develop policies in this particular field.
Yeah, not my opinion about whether Malta will ever legalize recreational cannabis. I don't know whether we will ever come to that. I do agree that use of drugs, in truth, in my opinion, always risks turning into an addiction. And we have to be very careful. And I do not have the scientific knowledge available, but 30 years working in the drug field, I have seen people who abuse drugs socially and never, ever became addicted to it. I have known people who were very addicted to drugs, all types, various types of drugs, who have managed to overcome their addiction and today occupy very high ranking and high flying positions in our country. I have seen people who started taking cannabis and ended up on the heavier drugs and who never managed to overcome that addiction. So I think we have to be careful. We have to understand there are some people, and the vast majority of people, who, yes, I know, are capable of not getting addicted, so to say, but it is obviously it is risky, and we have to pay a lot of attention. Look around us. I mean, great singers, great people like, I don't know, Whitney Houston and so many others, and so even friends of ours, friends who we know, who started on thinking this is something that doesn't matter, and then you become addicted to it. And I can speak about the dangers of addiction quite with quite some passion, because after all, I am a tobacco addict. And being a tobacco addict, I understand how difficult it is to overcome addiction. It is very, very, very difficult. When I smoked my first cigarettes at 16, 17, I'm sure that I said, well, I'm just having fun. I'm just defying my teachers. I'm just enjoying going to the toilet schools, thinking I'm doing something clever. We didn't have at that time the awareness that we had today about the dangers of tobacco. The truth is that I ended up to become a tobacco addict. And I have tried many times to stop, but I don't really manage to stop. I cut down sometimes I increase, but the dangers of addiction are dangers which I think every legislator should scientifically and analyze and keep in mind, because these are important decisions which could really and truly affect people's lives. I repeat, there's no steady and fast rule. Just like I started smoking in those toilets way back at school, so did others who started with me, and they managed to cut off their addiction. There were others who moved on to other things, and there are various people who I have met who have overcome their addiction, and today they employ 600 people with them, and they run a company like there's no tomorrow, and but we have to pay attention. But I don't know the answer to your question. I don't have this magic ball, uh, and I cannot predict the future. This seems to be the direction, but I agree very well with what Dr. Samud, Judge Bourgeois said, and Dr. Borge have said that we really, really need to be sure, just like the EU was sure when they realized that adding flavors in cigarettes enhanced or encouraged people to smoke further, and they therefore, the EU took a stand to prohibit them, and they came to that conclusion after they were scientifically informed enough to come to that decision. I think that also here in Malta, any decision on legalizing cannabis should be a wide discussion encompassing the various facets to it.
And one other point in relation to this aspect, touching addiction. Most of the time, addiction is in the mind. Of course, there can be actual physical addiction. For example, in relation to certain drugs, there would be a physical addiction to them. But most of the time, it's a question of how a person copes with the potential and the possibility of addiction. So, for example, Dr. Giulio mentioned use of tobacco. We don't see tobacco being prohibited in Malta anytime soon. Of course, successive governments try to deter people from smoking by introducing taxes or increasing levies on tobacco use and consumption. But essentially, that is more of an income generation revenue for government rather than an exercise in prohibiting tobacco. The same with alcohol, for example. When it comes to alcohol, I'm pretty sure that a real lot of physical damage is caused to alcoholics and to persons who, short of being called alcoholics, abuse alcohol on a regular basis. But there's no specific law in this jurisdiction prohibiting the use of alcohol. But then again, does it mean that each and every one of us can handle alcohol and alcoholic beverages um, up to a responsible level? Well, of course, the industry talks about responsibility and drinking responsibly and self-regulation and blah blah blah. We know people are fallible, and self-regulation is very, very, very difficult to achieve. But there again, as far as I know, there is no law prohibiting the use of alcohol in general. So why is there a law prohibiting the use of drugs? I think it's a question of the legislator realizing that the use and abuse of drugs causes harm to the individual and to society in general. And I think that is a sound argument, because of course, time and again, we see this damage in practice to individuals, to drug abusers, especially the ones who cannot finance the habit. So they resort to criminal offending in order to be able to have enough cash, enough money, enough resources to buy the drugs. So that in itself is very harmful, not only to the individual, but also to society. So you see, there is a correlation between harm being caused to the individual, harm being caused to society as a direct consequence of drug use and especially drug addiction. So there again, this question is a very complex one, and we should not trivialize it. We should not sort of render it petty talk. Serious analysis and scientific study has to back up policy decisions in this field. Otherwise, I think more harm can be done.
Thank you very much. A lot of interesting points were raised. And now this brings me to the last question of today's panel discussion. And it's actually on something which is not really related to what we're discussing. However, Malta, like a lot of other EU member states, actually set up a needle and syringe program, it's called. And for the purpose of the audience, I'm just going to explain that these are sort of public health measures which are aimed at reducing the transmission of blood-borne infections through a reduction in needle sharing among injecting drug users. And in February of 2002, which is quite a while ago now, SETA, the National Agency Against Drug and Alcohol Abuse, actually initiated this needle exchange program, which consisted of a system where safe disposal bins were given out. And basically after the injecting drug users were making use of such syringes, they would then be disposed in these bins and they would be properly disposed of. And in a lot of member states as well, there was also the introduction of drug consumption rooms. So the question is, do you think that the setup of such rooms would reduce illicit drug activity and drug use in Malta? Or maybe would there be better forms of regulation which would actually be able to reduce the use of illicit drugs in Malta?
I think, I mean, it has always, at least in recent years, there were always measures taken by governments admitting that there's a problem. We cannot completely eradicate it, so we try and control it. For instance, like the distribution of methadone. Methadone is an antidote to certain drug addictions. So if one is completely conservative and traditional, one can say this is encouraging the consumption of drugs. I don't agree. So even the exchange of needles already existed administratively, now perhaps it's being strengthened, is something which administrations do in order to control a problem which exists and that they know that they cannot eliminate. Okay? Now, what one has to be careful about is whether to take the other step and say, once we are controlling it in this way, why don't we solve the problem by decriminalizing it? And I would like to raise again the issue which Judge Budeya mentioned, I had mentioned before. If we allow alcohol and we allow tobacco, why don't we allow cannabis as well? This is it's a strong argument, but I think one has to put it in its proper perspective. First of all, the moderate consumption of alcohol statistically does not produce harm, while even one cigarette, if we get tobacco, and even the consumption of drugs, even limitedly, produces certain harm. Secondly, alcohol and tobacco have been around for the past 400 years since the discovery of America. To reverse this process would make each and every one of us a criminal. Okay. Now, this could be used also in favor, an argument in favor of decriminalization of cannabis. If the consumption of cannabis is so widespread and all the government initiatives of etc., are of no avail, one could consider that one could start arguing then we should decriminalize to solve the problem. I do not think that we should do so, certainly not at this stage. And we must ask also people from SETA and from Caritas who work on the field, what is their opinion? And I believe that till now, their opinion is completely against decriminalization of even the soft drugs. This could change in the future, but right now, this is the position.
To respond in, basically you are asking whether the setup of drug consumption rooms in Malta would actually reduce the use of illicit drugs in Malta. To be quite frank and honest with you, I don't think it will reduce the use of illicit drugs in Malta. These drug consumption rooms are something which have been adopted in the United Kingdom, if I'm not mistaken. They are mostly rooms where you can basically go and take your heroin injection and your cocaine injection, and there's also medical supervision many a times in these drug consumption rooms in some jurisdictions. Does this bring about with it a decrease in the illicit use of drugs? I have seen no scientific study that has said so. And when you are introducing drug consumption rooms, in truth, you have reached a stage where you are legalizing the consumption of drugs. And that is the first step that we have to be discussing, because drug consumption rooms presuppose, to a certain extent, the legal use of drugs. Are there better modes of regulation which could help reduce drug use in Malta? Yes. I think that if we wish to invest because we wish to reduce drug use rather than spending money on drug consumption rooms, I think we should create and spend more money on drug awareness. We should spend more money on the dangers of drug use. We should spend more money on educating our youngsters about the dangers of drug use. If you ask me I believe a government should be spending his money insofar as drugs are concerned, I would say that rather in drug consumption rooms, I would like to invest more money in SETA, who are doing a sterling job with so many people. Caritas, who are an organization that help so many people. OASI are another organization that help and contribute a lot. These are organizations which could also receive help and assistance from the state, and therefore, rather than, to be quite frank and honest with you, introducing drug consumption rooms, I would rather try to reduce drug use by these means that I am explaining, which is education, awareness, and giving more funds to these organizations who do a sterling job and who obviously work within very, very, very limited and very difficult scenarios. Nina, I don't know if you have ever been to a drug graduation ceremony, but the joy that I have seen in the eyes of ex-drug addicts who would have gone to a drug rehabilitation program and reach their drug ceremony graduation is one of the most amazing experiences that you can live. And therefore, since I have lived on various occasions and attended these drug graduation ceremonies, I tend to believe that helping these organizations would be more fruitful rather than the introduction of drug consumption rooms, which, as I said, presuppose that the legislator has actually accepted the legalization of drugs.
If I may add one point, here we are focusing on certain illicit drugs. And what about the other recreational drugs, such as, for example, ecstasy and other drugs that are consumed within the partying context? How do you tackle those? I mean, recently I have had a case where a court expert clearly stated that drug dependency and drug addiction can also happen with the use of ecstasy and similar party drugs, which is also very interesting. How do you go about? Now, it could be that a person becomes addicted to partying during weekends, and during weekends, this person uses and abuses considerable amounts of ecstasy pills during party going, of course, for the kick of it, in order to have the buzz. But then he or she could be clean the rest of the week. And even that, from a technical scientific perspective, seems to be considered to be a form of addiction. So how do you treat these people who would suffer from that form of addiction? I agree completely with Dr. Giglio here. I think the state should well invest its funds with these agencies and drug awareness campaigns, because at the end of it, I mean, people have to realize the dangers coming from addiction to these substances. Because as Dr. Giglio said, I mean, you can have a person who might have a recreational use of a certain drug without becoming addicted to it. Whereas another person, given the same amount of drug, might eventually find himself immediately hooked by it. So this is the danger that there is. It is like COVID, you know, to a certain extent. I mean, you never know if it's going to affect you or not. But once it affects you, it can affect you really hard and really bad, you know. Is it worth to take the risk? Personally, I don't think so.
Okay, thank you very much to all the speakers. I think it was actually a very fruitful discussion. I don't know if anyone else has anything else to add, but from my end, we've gone through all the questions. Like I said, it's been very interesting, even from my end as a student. I haven't really researched much about drug use before today's discussion, so it was very interesting, even getting some personal and actual examples of how it works in practice. So thank you very much for that. It obviously would have been nicer if we would have been able to do it in person and actually have an audience in front of us. However, it was the best which the organizers could do in this current situation. So thank you to all the speakers for attending and giving us your opinions. And also, I'd like to thank the organizers once again, KSU, ELSA Malta, and the SO. Thank you very much, and wishing you a good evening.
Thank you for the invite. Proset, well done.